I'm Dave Gillis, and with me is Matt Kemp. We're members of Godfrey & Kahn's Environmental and Energy Practice Group, and we're also co-authors of an article that's going to appear in the June Wisconsin Lawyer about greenwashing, or overselling a product's greenness. What the article does essentially is talk about new standards for environmental marketing claims. If your business clients are interested in promoting environmental characteristics of their products or services, you will want to be familiar with these standards. Now, what sort of claims are we talking about? Well, if you go into a grocery store, you'll see green seals on product labels. If you review advertising that represents products are eco-friendly or made with renewable energy, you'll encounter on the internet offers to eliminate your carbon footprint by purchasing carbon offset credits. These are the type of environmental marketing claims that have been highlighted in the proposed new standards. Now, what is greenwashing? Well, it's a term that's been coined to describe vague, unsubstantiated, or misleading environmental marketing claims. With this, I'd like to turn it over to Matt to talk about and describe some recent allegations about greenwashing that have appeared in cases and in the courts.
Sure. One thing to note here is that greenwashing liability can come in from a variety of different directions. First of all, on the federal regulatory side, the Federal Trade Commission has authority to bring enforcement actions under the FTC Act. One recent set of cases that the FTC settled was against some manufacturers of windows who had claimed that their products, if installed in a home or business, would result in certain energy efficiency gains. In the FTC's view, these energy efficiency claims were not substantiated and so represented deceptive advertising, and the manufacturers settled those claims with the FTC. State attorneys general also have authority to bring greenwashing claims under state consumer protection or deceptive advertising statutes. Wisconsin has a provision like that as well. A lot of the action in this area has been out of California. The California Attorney General recently brought a case against makers of plastic bottles who claimed that their bottles were biodegradable because they had a microbial additive. The California Attorney General did not believe that that claim was appropriate in those circumstances, and so filed suit against the makers of those bottles. Greenwashing liability can also come from competitors who have standing to sue under the Federal Lanham Act, as well as under some state statutes. An example of a recent Lanham Act claim involved the maker of reusable, durable shopping bags, who had made a number of statements, not about its own products, but about the products of conventional plastic bag manufacturers. And these conventional plastic bag manufacturers took exception to what the competitor had said about their products and filed suit under Lanham Act. This was dubbed a reverse greenwashing suit. The parties eventually settled and both agreed to essentially tone down their rhetoric about the other's products.
So, Matt, in late 2010, the Federal Trade Commission proposed revision to its guidelines for environmental marketing. They're affectionately called the Green Guides. What specifically did they address? Can you give us some examples of the types of claims that they were, or the types of guidance they were proposing to give?
So the Green Guides give both general guidance about deceptive advertising in the environmental context, and there the basic lesson is be specific about your environmental claims. Don't just say this product is eco-friendly or environmentally friendly. Be specific about what particular environmental attribute you're claiming, and also be able to substantiate those claims with preferably scientific evidence. And then the Green Guides also go through a litany of specific environmental catchwords that manufacturers or sellers of services like to use. A number of these have been around for a long time. Words like biodegradable, recyclable, But the Green Guides also address some terms that are of more recent vintage. They would include claims about carbon offsets and renewable energy, claims that products are made with renewable energy.
And Matt, if you're working with a business or a client in Wisconsin and you have a concern about these types of practices, there are a couple places that you can look to for enforcement authority, and that would be the Wisconsin Attorney General's office, which is responsible for enforcing the deceptive advertising law and the unfair trade practice law, and also the Department of Agriculture, Trade, and Consumer Protection, which has administrative responsibility with respect to those laws, and has, in certain instances, promulgated rules dealing with specific types of claims. Matt, what remedies available for businesses or consumers that are that may be adversely affected by greenwashing?
So Wisconsin statutes do provide for a private cause of action for consumers and competitors that may be harmed by deceptive advertising, including greenwashing. You could recover both damages and get injunctive relief as well as attorney's fees.
And more information about this topic is set forth in our article that's going to appear in the June issue of Wisconsin Lawyer, and it's also going to be addressed at a webinar will be held on June 28th at noon. So thank you very much.